I call this meeting open at 9:20 p.m. and let's go on to the adoption of the agenda. Go ahead. I move that the agenda that is before us be adopted as presented. Seconded by Councillor Zant. I have an addition to this, Mr. Mayor. Go ahead. Where do we add any items that need to be added? 8.2, parking on Albert Street. Fine then. Any other changes? Thank you. Let's go on now to disclosures of pecuniary interests. None? Fine. Presentations. Overhaul of the planning appeals process, Mrs. Bélanger. Well, I'm here to talk to you about Bill 139. That is dubbed the overhaul of the planning appeals process. It's a bill Bill 139 was implemented on April the 3rd, 2018. It's now called the Local Planning Appeal Tribunal that replaces the Ontario Municipal Board hearing process that everyone's aware of, and will call it now the Local Appeals Tribunal. Now, if you hear this moniker, it means the Local Area Appeals Board. There are many changes that have been brought about with regards to this planning appeals process. I'll highlight the major changes brought about. One of the modifications or changes, one of the new standards followed by the tribunal with regards to official plans or zoning modifications enacted by the town council. If there is an appeal, the appellant needs to explain or show how the modifications or the changes brought are incompatible with provincial principles, do not conform to a provincial plan, or are incompatible at superior levels with regards to provincial plans or directives. If they're incapable of demonstrating that the decision is incompatible, then the LPAC has the legal obligation to reject the appeal. So the appeal could be rejected at that time by this particular tribunal, this new appeals tribunal. The second major modification is this one. If council or the city refuses to adopt or to enact modifications to the bylaw, there are two steps that people have to go through. Number one, the appellant needs to explain how existing policies are incompatible with provincial directives or the official plan, and how the modification that is asked or changes that are asked conforms or is compatible with a zoning document. So though both of these tests need to be met, otherwise this appeals tribunal might decide to reject the appeal. However, in cases of appeals for the refusals to enact, if the appellant is satisfied with the new directives with regards to appeals, the tribunal might reverse the objection to the appeal and proceed to a new examination of the matter. So if council refuses zoning change to the official plan and the appellant does clearly show that council's decision is incompatible and meets both tests that I've outlined, the tribunal, if it deems that it makes sense, will bring the file back to council to take a new decision or to reconsider. The council needs then to meet a second time and discuss anew this particular matter, and council will come up with a new decision. At that time, when the new decision comes out, on behalf of council, the tribunal might reverse the decision, and an individual can appeal to this new by way of a notice to appeal to this new decision of council. So all subsequent decisions or omission to take a decision might be subject to an appeals, and the tribunal might call a hearing to hear an appeal. There'll be also mandatory case conferences that have been enacted. The tribunal must proceed through a case conference with regards to appeals concerning land planning matters. Wasn't that the norm beforehand? Well, I'm not sure at present with regard to the difference right now. Uh, this process involves the appellant and the municipality, and people other than the appellant might take part in this particular process. I think that might be different than what happened beforehand. And does proceed different than preparatory hearings in the criminal domain, if you wish. Now, beforehand, there was a board member up in front, and on either side, there were lawyers that were being heard, and people were being cross examined. This is finished now. This process is now ended. Uh, Audiences can be held in a written manner, electronically, or viva voce. Only the court can call witnesses or obtain testimony through a written declaration. So let's say if the tribunal calls me up, for example, to have my to hear my oral interpretation of things, it can allow me up to 75 minutes to plead my case, and then the matter is ended. The tribunal might choose to do this with individuals that are involved in this matter. There won't be any back and forth. It's going to cut a lot of lawyer costs. But can the municipality can propose any names if it needs to hear witnesses, or does the tribunal ask, do you have any witnesses, or some such thing? No. The tribunal will allow up to 20 days for documentation to be submitted, and at that time we might ask the tribunal to have people added, such as a lawyer or an urban planner, for example, to address the tribunal. But in effect, the tribunal might say no to this. What we understood throughout that process was that people needed to hire their lawyers or their planners at the beginning of the process, so that these people might be incorporated in the system before it appears before the OMB. If people decide to hire these people at the time when the process is ongoing, it might be too late. So the appellants need to show at the very start, need to come up with a list of witnesses that will appear on their behalf, as well as the municipality. So it's a new process, and people will be learning on the go as things go by. The United Counties wind up in the same situation also. We don't know where things might be heading, ultimately. There are a lot, we'll be doing away with a lot of manners of appeal. For example, if an official plan is adopted, the minister who's the approval authority will not have a right to appeal. This means that if the county comes up with a new official plan, he will have no right of appeals on this new official plan, because the minister is the only approval authority with regards to the new official plan. So this process will be much shorter. There will also be a 2-year moratorium with regards to amendment requests on the secondary plan. At present, we're proceeding to the drafting of a secondary plan for the expansion of Clarence and Rockland, and when it's approved, there will be a 2-year moratorium. And once this is approved, we have no right to receive further modifications for this particular sector unless council deems it proper to approve a resolution to do away with the 2-year moratorium. Now, the previous official plan, is it subject to this? No. Only the secondary plan is subject to this. So the secondary plan is subject to a 2-year moratorium at the date of the adoption. So we cannot request a modification for a 2-year period. But, that's right, but the plan that is in existence, well, we don't have a secondary plan that is officially enacted right now. It refers, we always refer to our official plan. What I'm telling you now refers to a secondary plan that this council has not yet enacted yet or implemented. Now, with regard to delays, concerning delays, because there's a lot of back and forth, and reports are quite lengthy when they're drafted. We come up with a fairly detailed report. They've decided to prolong this process by some 30 days. So that affords you 210 days of preparatory time, 150 days for zoning change, 5 months, and 150 days for a deferred change to be considered. That's what the minister requires. Usually, we're involved in 3 to 2 months when we're involved in a complete process. So the process has been prolonged. Yes, yes, because we need to incorporate a bit more information at the very start. We have less steps to go through, but the process is a bit longer, and the government affords us more time to prepare our position if we need more time. But yes, indeed, but ultimately it won't change much. It won't change much. It won't impact us much as far as time frames go. The other thing they've created is a help center, which is an independent organization sponsored by the province. So the Appeals Assistance Center informs citizens with regards to planning, gives out judicial or legal advice, and so this particular department is called the LPASC. The LPAC signifies the board. The LPASC signifies the support center. And I received a call from them. I'm surprised that I received a call from the LPASC, the help center. I was quite surprised, but they're there to help out people in filling out the appeals documents and steer them in the right direction and guide them through the steps needed to be taken to launch an appeal. And that's the new process. This is the gist of my presentation. Basically, there are many changes that have been brought about, and we won't hear talk about the Ontario Municipal Board anymore. We'll become acquainted with this new tribunal. Let's go on now to item 5.2. Mr. Taillefer's letter. Mariette's aware of this matter. Mr. Taillefer's letter was sent to council, and it's a letter from Jacques Taillefer in regards to solar array. And he built a solar array on town property, and he's asking for a permit or to rent out his property. I thought that he mentioned that this was built on a property adjacent to his property. That's a municipally owned property. I noticed that his solar array was at the back of the property, but there's still a residence. Yes, that's his residence. Mrs. Bélanger? Yes, yes, Mr. Mayor. Let me give you a bit of a background concerning this. I noticed that there was something on the municipality's property, and I asked what was on the municipality's property, and he advised me that this was a solar array, and the town official told me there's nothing on the file that I have with regard to this property that deals with solar panels or solar arrays. And what happens was that Mr. Taillefer had hired consultants, and consultants were supposed to ask permission from the municipality to install solar panels on the municipality's property adjacent to a creek. It's a strip of land that the municipality owns, probably that 30 or 15 meters worth of buffer from the creek, and the solar panels were installed there. Mr. Taillefer has no documentation on hand to to the effect that a request was made or anything like that? No. He says that he hired consultants and the process is now ended. He's asking for a 100 annual fee. I say we can charge him $100 per year. I don't know how many years he's been there and he's been paying rent there. Well, if we authorize citizens to install solar panels on the municipality's property, can we not create a precedent by doing so? There might be others that will make use of municipal lands to put up anything, really, signage. Or anything else. He's asking if we could rent this out for $100 per year. Well, what I mean by that, we should impose a penalty upon him for having done this without a permit. Didn't anyone object to solar panels being put up there? I know that something similar happened in Hammond and neighbors objected to this. There's also someone who followed through on a similar project. That's in Clarence Creek, and he encountered problems because of neighbors' complaints, and he needed to remove these solar panels. I think in this particular instance, it's hidden. Well, there are two neighbors that can readily see these solar panels, notwithstanding here. Let's drop an agreement. Let him pay the legal documents needed to come up with such an agreement, and let's allow him to operate. Well, or allowing him to do so. Yes, we'll allow him to operate this. But if these panels are broken in any way, shape, or form, if it's not financially feasible for him to continue operating this, then we'll just put an end to it. Mr. Zant, this is in your ward. No, it's in Mr. Grimard's ward. Mr. Taillefer contacted me. I contacted Mrs. Bélanger to do a bit of work on this, and I then contacted Mr. Grimard so that he may follow through with what we initially did. How much would it cost to have these panels moved from one area to another? It would cost quite a lot. How can someone invest such a large amount and to put up an installation on a property that doesn't belong to him? Good question, Mrs. Chouanière. I can't answer this on his behalf. I believe that, conversations I had with him is, he told me that when you deal with certain companies, these companies will take care of the issuance and obtaining of permits. He must have known where the limits of his property did lie. Well, if he would not have sold his home, we would not have been made aware of the situation. So the agreement will be drafted with him or with the new owners? Well, with the new owner in the case of him selling his house. You see, that's what's dangerous when we enter into such an agreement. Each and every time that the house will be sold, it's going to be further work for us to go through this rigmarole again. Well, Mr. Boucher, I suggest that we ask a legal opinion as to this, because this is built on municipal lands, and we'd be creating a precedent. He installed these solar panels without our being aware of this. I phoned up Mr. Means to make him aware that he was held fully liable for all of this. Ultimately, he had many options that he could follow through with, but he chose to compel the owner to appear before council to come up with a solution. Well, the solution I came up with was to draft a rental agreement, but I could advise the lawyer saying, well, this is what council decides, and if there are any lawyer fees, then they should be paid out by Mr. Taillefer. Yes, let's ask for a legal opinion, as Mr. Boucher suggested, and we'll come up with an answer then. And with a cancellation provision, that we have a right to cancel this agreement within a 90-day period. Yes, well, we'll ask a legal opinion. Even then, in other instances, citizens oppose themselves as to this project, similar type projects, and the authors of these similar type projects were called upon to put down what they put up. So we'll ask the lawyer his opinion as to that. Letter from Ernie Hardeman, MPP Oxford, to support Bill 16, respecting municipal authority over land filling sites. Are you in favor of supporting or receiving? Well, I'm concerned about this. There might be a lot of politics involved with regard to that. I saw a lot of sandpit requests with regard to this or concerning this, and people then object to sandpits being put up behind people's backyards. So I just move to receive. Fine. Notice of motion. Councillor Jean-Marc Lalonde. Yes. Whereas some registered non-profit organizations have expressed their need to install their ground signs outside of the premises of the organization to which it relates, this being prohibited under Section 9.14 of the Signs Bylaw 2015-160 as amended. Be it resolved that Town Council mandates Town Administration to prepare a document to amend Bylaw 2015-160 dealing with ground signs to exclude the application of Section 9.14 that would apply to registered nonprofit organizations. Seconded by, well, it's just a notice of motion, so seconded by Councillor Berlinguet. Do we need to go through a public hearing for this? Well, let me explain my rationale behind this. You see, the Optimists Club wished to change their sign upon, the one located upon entering Rockland when one drives by Laurier Street, and there's another sign on the other end of town that's fairly beat up. And when they obtained a permit to install a new signage, they were told you don't have the right to do so unless you decide to put up signage smack dab in front of your business or your offices. So what we have before us applies to churches and so on and so forth. I looked in front of your independent store. There's a church right in front there, so it's illegal to proceed with new signage there. It seems to me that when we enter into Rockland by the 174, aren't there many signs put up one after the other? Did we not authorize the putting up of signs there? Yes, those signs are put up on private property. We seconded that initial motion. I see. This is on private property. You see, they have no right to put up signs there on the side of county-owned roadways, however. So does this mean that he could that they could put up signage? Well, yes, but providing they obtain a town permit. At present, they can't even obtain a permit because signage is not put up in front of their offices. Why not do what a lot of municipalities do? When you come into town, there's a sign that lists all of the community groups within that particular town with their particular logos attached. So people know that they have a Richelieu Club, an Optimist Club. Well, they have this similar type signage in Clarence Creek. We'd have to modify the bylaw. Well, if we do modify the bylaw with the stipulation that signs be put up at the entrance and at the exit of individual villages. Well, we can't put up signage everywhere, here, there, and everywhere. Well, the signage that announces Clarence Rockland, and then the village of Rockland, and then another signage when exiting Rockland. It's clean. Are you in favor? It's a little bit like Tourist Ontario signs that are put up. Are you in favor? Are you in favor? Yes. Fine then. Item 6.2, that the administration be mandated to prepare parking to prohibit parking in between 2322 and 2400 Albert Street. I'd like to deal with this subject. At present, we're allowing parking everywhere on Albert Street, and Albert Street is not all that wide a street. There's only parking allowed on one side, and entrances leading to two condo units are located on that side. People leaving the condo unit and getting onto the street have a hard time seeing oncoming cars, you see. So, so I'm talking about the north side of that particular street. I'd like to request an exception then to the bylaw to ask for an exception for that. So we're talking about two cars or four cars that are involved. I'll have Mrs. Ouellette speak to this. We might come up with a proposal to ensure that people are safe. So I'm asking our town clerk to draft a proposal that might meet our wishes concerning this. Will someone second it? Fine then. Let's go on now to question period. You have no questions, Mr. Payet? No questions? No, no questions whatsoever. Thank you. Let's go on now to the reports from the United Counties of Prescott-Russell. Again, we're dealing with the ambulance matter. Does Ottawa pay? Does Cornwall pay? It all depends on where things are heading. We have $1.5 million. We have an invoice of $1.5 million to pay concerning ambulance services stemming from our municipality. Let's go on now to committee staff reports. New parkland dedication law. The Council of the Whole mandate that Council adopt a bylaw with regards to parks as recommended by the Infrastructure and Land Planning Department. Seconded by Councillor Berlinguette. Any questions? Yes, I do have a question. Go ahead. Did Mrs. Claire Lemay propose this? Well, the department asked for this. Mrs. Lemay is an urban planner working for the department, and she's the one that drafted the report. And who had this idea? Well, the department had this idea. All I wanted to say was that this was a very nice initiative. That's all I wanted to say. Well, that's fine. I don't want to accuse anyone here. I'm not pointing the finger to anyone. He wasn't sure whether he might say one thing or another. All right, you're green lighted for this comment here, to make this comment. Fine. So let me just I'll relay your congratulations to the people involved. All those in favor, carried. Item 9.2, Councillor Chouanière, awards for purchase of a front-end loader. The Committee of the Whole recommends that Council authorize the execution of a contract with Nortrax Canada Incorporated for the purchase of a new front-end loader in the amount of $175,000. That's it. Seconded, well, excluding HST, of course. Seconded by Councillor Lalonde. Any questions? All those in favor? Thank you then. All right. Do you have a question? That's a forestry matter, isn't it? Mr. Mayor, why does the name Rona appear in the recommendation? What can I say? If it's a forestry matter. They might have interests in our local forests. All right. Purchase of a one-ton truck. Councillor Levert. What? Are we purchasing a one-ton truck, Mr. Mayor? The Committee of the Whole, Mr. Mayor, recommends that Council adopts a bylaw to authorize the Mayor and the Clerk to sign a contract with Donnelly Automotive Group for the purchase of a one-ton truck complete with a dump box for the sum of $53,371, excluding HST. Seconded by Councillor Chouanière. This item was already included in the budget beforehand, right? Yes. Any questions? Go ahead, Councillor Levert. I'll have the same question that Mr. Lalonde will probably have. There are no other dealers within the Clarence-Rockland area that can offer us this. There were $1,000 more expensive, well, Rockland Ford, but And it was a competitive tender process that we did enter into. So Rockland Ford was $1,000 more expensive. Well, Rockland Ford said that they never learned of this. They submitted the price. They submitted a tender. Well, they told me today that they were made aware of this because they don't subscribe to Merck's. No, sir, they submitted a tender price through the tender process we went through. Fine. All those in favor then carried. Item 9.4, Councillor Simard. That the Committee of the Whole recommends that Council adopts a bylaw to authorize the mayor and the clerk to sign a contract with ASCO Construction with regard to 13055 Ontario for an amount of $521,000 and two, excluding HST for the replacement of a culvert, and that the Committee of the Whole recommends that Committee or Council authorize to make an exception to the procurement policy to authorize the Mayor and the City Clerk to sign a contract with Stantec for the administration supervision during the construction on Lacasse Road for the amount of $73,329, excluding HST. Seconded by Councillor Berlinguet. Any questions? Councillor Berlinguet. How much was the budget? $985,000. How much was that's the budget that was allocated for this type of work to be performed? Yeah, $985,000. There was a major difference in prices tendered. Well, they needed to modify the tennis complex. We'd budgeted 500 and it costs us 259. Well, this is money that we can tap into to shore up the daycare shortfall. Yes, I'd ask the same question. Gee, ladies, you're quick tonight, I'm telling you. Yes. Any other questions then? All those in favor? Carried then, thank you. Let's go on now to rural economic development program. Councillor Lalonde. I don't mind reading this, but I'm not in favor of it. I'll read it for discussion purposes. Whereas community services have requested a grant from Ontario's Rural Economic Development, the RED program, through Ontario's Ministry of Agriculture, Food and Rural Affairs, and the project identified in the application was approved for an amount of $55,000. Be it resolved that Council adopts a bylaw authorizing the Mayor and the City Clerk to sign the agreement between the City of Clarence and Rockland and the Province of Ontario. Be it resolved that Council commits itself to pay 50% of the costs related to the project identified in the agreement as recommended. Seconded by Councillor Simard. This is for the purpose of obtaining money at plans and specifications. Right, Mr. Boucher? Yes, a request was made concerning the Jean-Marc Lalonde Arena. However, if we receive another directive that is contrary to this from Town Council in subsequent months, we might redirect the request to cover two buildings instead of just one. That's what I was going to ask him. So what I stated was this, is that possibly we might redirect the request. It doesn't mean that they'll accept this new concept, but this is what we thought we might do if ever the initial project proposed by this service does not go ahead. I say the following, Mr. Mayor. We can do whatever we wish to. We'll make use of this in the way we deem it appropriate. We'll just draw plans and specifications and have them approved, and that's it. Matters will end there. We've received the grant, and we have to enter into a signed agreement to obtain the grant. And if there are modifications, then we might bring them afterwards, right? We might apply them afterwards. Councillor Chouanière, once again, Mr. Mayor, if it's too expensive or if it's not Council's wish to go ahead with this project that you're involved in concerning the Jean-Marc Lalonde Arena, could we not start or begin planning with a view of coming up with financing of a complex that is multi-purpose in nature, as is seen in many municipalities, that might accommodate soccer fields as well as other sports. Mrs. Chouanière, Do you know how much that would cost us, what you're proposing right now? Take a look at what happened last week. Well, how many millions did we say it would cost us to repair the roof? Mrs. Chouanière, I'd like to talk to you one-on-one with regard to another subject. This particular grant could not be redirected to another project other than this particular project unless we were given the green light to make use of this grant for two projects. We have two buildings that are currently being assessed for this purpose. If council deems it proper that we keep both buildings and that we invest in both buildings, then I will put forward a request. Well, the recreation department garage and the arena. Those are the two buildings. It might be used for both of these buildings. All those in favor then carried. Thank you. Item 9.6, the award of a contract for the Storm Water Master Plan. Councillor Simard, that the Committee of the Whole recommends that Council approves a bylaw to authorize the Mayor and the City Clerk to sign a contract with the WSP Group for the execution of the Stormwater Master Plan in the amount of $190,843, excluding HST, and that the Committee of the Whole recommends that Council authorizes the Infrastructure and Planning Department to manage the provisional items for a maximum amount of $40,000. Seconded by Councillor Berlinguet. Any questions? I do have a question, Mr. Mayor. What's the $40,000 for? Well, the $40,000 is applied to provisional items. This is the first time that we commission such a study, and there are some things that we're not making use of on our network right now. So we've asked our consultant, basically, to make us aware as to what time of provisional items or amounts we might obtain to come up with missing information, and based upon the size of our network and the information that was put forward when the tender documents were drafted, they told us then that this would be sufficient in case we were missing any information. It's something like a contingency fee or contingency measure. Well, it's really not a form of contingency. They're requesting information from us. And if we're missing information, if we're lacking some information, they're saying when you come up with a master plan, you'll have to come up also with missing information that we're requesting. Well, I thought we'd gone through this process. You determined at one point in time that there was a flooding here, there, and everywhere. Let's just send this over to the United Counties to see what they think. Well, that was never done beforehand. The counties sent this to Eastern Ontario. Well, I remember that we had a similar type situation that arose at the back of the clinic that impacted the development. Well, that was a different set of circumstances that dealt with a specific area. This is the only master plan contingency that we're missing right now. So, yes, they'll take a look at the network. They'll determine where the constraints are owing to the capacity of the network. And they'll take a look at any future developments. What type of water treatment policy might be applied, ponds or whatever, and what areas might be appropriate to receive such treatment or to be subject to such treatment. And maintenance involved, just to avoid also that individual development projects have their own ponds. That's right, and it does reduce costs. This has already been budgeted. Yes, it has already been budgeted, and we have savings already that we've set aside, including the $40,000. All those in favor then carried. Let's go on to daycare services policy, reimbursement of service fees. Councillor Berlinguet. Whereas the community services received a request from four parents asking a reimbursement of daycare fees for the services that were not rendered due to the fact of the closing of the daycares for the ice storm of mid-April 2018, and whereas the service must take into account the budgetary restrictions that the daycare services face for the year 2018, and whereas the service recommends to municipal council not to depart from the existing service agreement, Committee of the Whole recommends that Municipal Council hereby refuses the request for the reimbursement of the daycare fees for the days that were cancelled of the daycare services as recommended. Seconded by Councillor Sima. I believe that schools did close. That Mr. Boucher, yes. If schools were the root cause of this, they should be held liable. And of course, parents should make provisions when schools close to keep children at home then. Did we still pay our employees on that day? Yes, sir, we did. All those in favor then carried. Let's go on now to 9.8. Purchase and installation of a level 2 charging station at Town Hall. The Committee of the Whole recommends that Council approves the purchase and installation of a level 2 charging station at City Hall in Rockland, and that we hereby recommend that Council authorize the transfer of $2,700 from the Building Reserve Fund to the operating budget for the purchase and installation of an electric vehicle charging station. Seconded by? I can second this, yes. Now, the government hands out grants to those who purchase electric vehicles. Do they also give out grants to add on to charging station networks? I believe there was a Montreal-based company that had consulted with us, that had appeared before council, that stood ready to extend our services. We paid for the installation. Well, that was about 2 years ago. I can't recall exactly what was stated. Well, if governments give out grants for electric vehicles, I believe that we should, if we can receive grants, then that's fine. Well, I believe we do have employees that drive electric vehicles, but this applies to all residents. There's no exchange provisions. It costs about $1 for a complete charge up. They can make use of this. It's only one plug. If an employee is plugged into this charging station, well, at this point in time, there are employees that are charging their electric cars. One or two employees have electric vehicles that are charging their electric vehicles through a local, through normal plug-up apparatus. Well, in the good old days, we used to tie a team of horses to a post, and they just take a rest. Well, are we charging people to charge their electric vehicles? No charges are asked. And the fact that when they charge up their electric vehicles, they have the opportunity to shop locally when their cars are being charged up. I spoke to someone who's familiar, Mr. Mayor, with electric charging networks. Well, they're involved in this. But I don't think this should be paid out entirely by the city of Clarence and Rockland all day long, to accommodate those driving electric cars. If an individual is parked, let's say once they've charged up their car after 1 year, that they need to leave this charging station and have another person charge up his or her car. Well, I believe that they can charge up electric vehicles within 1 or 2 hours. Or, well, if you're driving a level 2 car, you can charge up a car within a 4-hour span, I think. I just don't want this to be used by town employees. If we have charging stations, they have to be used by everyone and made available to everyone. All those in favor? Well, we need to obtain a grant. We haven't specified this. I would request that we defer this situation and be made aware of whether or not we'll obtain grants or not. Well, I noted that the charging station network will be expanded throughout Ontario. A company was involved in this throughout the province of Ontario. We might look into this, Mr. Boucher. I heard of this during the last few months. We'll defer that to obtain more information because I believe they were part and parcel of this network that we referred to in our discussions. I believe this matter came up to council for a decision, and there was a grant that was offered for us to implement the building of such charging stations. All right, the matter is deferred. All those in favor of deferring this matter for further consideration, fine. Item 9.9, Councillor Levert. The Committee of the Whole recommends, Mr. Mayor, that Council consider the adoption of an amendment to the current dog bylaw at its next regular meeting in order to allow 3 dogs per household plus any service dog that may be clinically assigned to a person living in that household, and to allow 5 service dogs in training, and further allowing rescue centers to have up to 20 dogs in its care as the dogs transition to new homes. Seconded by Councillor Simard. Fine questions? Councillor Levert. Well, I don't know how to ask the question I have in mind here. Did we not come up with a bylaw as to this? Yes. Well, we came up with a bylaw that dealt with horses. I believe we dealt with this at the Municipal Affairs Tribunal level. I believe on the Rolin Road, we dealt with a similar matter that was heard by the Association of Municipalities Commission. Some people are asking to have 3 dogs at a townhouse with a small backyard to it. 3 dogs, you know. I thought that this is what we were dealing with. There are 3 dogs per residence. Might be the standard. Well, 3 dogs, but if you want to train a dog, you need a sufficient backyard space. One at a time, please. One at a time. Mr. Kehoe. We might defer that until next meeting.
If there's more questions.
But before deferring, I'd like to make one point. If it's just for one specific individual, we'll have to put down the address, because I wouldn't want to have this, hey, there's a dog that barks day in and day out. I wouldn't have that type of complaint laid down on my doorstep, because they're asking this in a residential, for this in a residential area. Well, let's defer this to obtain more information from Ms. Collier. We don't have any bylaws that would govern this particular situation. Mr. Kehoe, Mr. Mayor, if we can identify matters that need to be dealt with later on tonight, we can do so, and we'll send you further clarification through emails. Well, let's defer that. Well, the SPCA stipulates what would be the maximum number of animals in a house or a household. I'd like to determine how many dogs they will allow on a per residence basis, what the SPCA recommends. I believe we'll obtain what we need at the next meeting. All those in favor to defer this matter, thank you. Let's go on now to other items. If you have any questions, let's go ahead. You have any questions? Mr. Kehoe. Yes. Earlier on, you told me that Rockland Ford had tendered through our tender process. I was approached by Fashion Workwear, and they've been servicing Rockland needs with regards to safety, uniforms, and so on and so forth. And they decided they were never invited to submit to a tender process when we came up with a permanent offer. The City of Ottawa now mention, well, if we need a pair of boots now or work clothes, we have to go down to Ottawa to obtain it now because they obtained the contract, and we have to pay an extra $50 to get this because people are paid $25 to go and obtain these work clothes or safety clothes in Ottawa because they had the winning tender. I spoke of this to Mrs. Collier, and this business has been here in Rockland for the past 18 years. I wasn't even aware of this, and they supply all of our local offices. Well, so what is the question then, Mr. Mayor? How was it that Fashion World, how come we went to a permanent tender and Fashion World, which is a locally based business, was never made aware of this? Well, Mr. Mayor, merchants have a certain responsibility to tap into the town's website or register to the tender network. Well, they've been operating for the past 18 years. They ought to have known. But they don't subscribe to OMER. They could have consulted our website. The onus is upon them to consult the town's website. Maybe at present, employees are complaining we have to run down to Ottawa now to obtain our work clothes and safety clothes. Don't we have an open account with Fashion World? And we could still obtain clothing there. Well, that's not our way of doing things, Mr. Mayor. Once we've entered into a tender process and we've approved a tender, we follow the following policy. If it's anything over and above $25,000, we need to obtain 3 tenders. We might obtain a tender from Fashion World, but if they're not the lowest, well. But let's take a look at other situations. We saved a lot of money by dealing with outside contractors. Well, let's hope that the employees obtain those clothes on their own time and not on the company's time when they obtain clothes in Ottawa. Councillor Levin, I understand what Mr. Keogh has stated. It's the business's responsibility to do so. But if the business has been catering to our needs here locally for the past 18 years, I think it might be wise to advise them that we're resorting to a standing offer process and they should tender. Don't you have a list drawn up of those businesses? Well, let's say when there are some notices that appear on Facebook and so on and so forth. The problem is this, Mr. Mayor. We might ask the administration to drop a list, but it requires a lot of time to update that list. That would take up time otherwise more wisely spent by our employees. This is something we might consider doing, but we have to take a closer look at this. Well, we might then educate people, making them aware that it's important to consult the town's website on a regular basis. Councillor Zant, each and every time that a business obtains its permit, you give them a letter saying, subscribe to OMERX. We will now be submitting bids on these many places. If you wish to bid, go on MERX, and that's what we'll do. And you hand it out for each and every permit that is issued, and the onus is upon individual businesses to follow through. Fine. Any other questions? All right. Adjournment called at 10:12 p.m. Thank you, folks.